The next bill on the calendar for the day is Senate File 3492. The clerk will report the bill.
Senate File 3492, number 2 on the calendar for the day, an act relating to housing, the third engrossment.
Representative Agbaje, before you explain your bill, do you want to put the House language into your bill?
Yes, Speaker.
The clerk will report the amendment.
Agbaje moves to amend Senate File number 3492, the third engrossment. The amendment is coded DEA 3591.
Representative Agbaje.
Thank you, Madam Speaker. This is the bill from the House file, and I'll just briefly introduce it, and then we'll go on to the next amendment. So this bill provides protections for tenants to help provide safer and more dignified living spaces. Renters deserve to feel at home in their place, and that requires landlords being held accountable if they don't uphold their end of the deal by keeping the unit and common space fit for use. This bill includes new policies related to landlord-tenant law, as well as clarifications to policies passed in last year's landlord-tenant package. The purpose of this package is to continue with policies to further make clear the responsibilities of tenants and landlords in their residential relationship. One of the ways to do that is through the tenant right to organize provision in this bill, and that allows for tenants to organize with each other without fear of retaliation, of eviction from their landlord. The bill provides for how a tenant organization can be created and the type of efforts they can engage in to create a better living situation, including the terms and conditions of the tenancy. We know that this provision will further foster community and allow people to better engage with their landlords to provide a healthy living environment. A few additional policies in the package to highlight are ones that ensure that tenants can call on emergency services in a mental health crisis without fear of eviction, prohibit discrimination based on the source of income that you use to pay your rent, and clarifies that only the most up-to-date court records are shown on a tenant screening report to help limit the number of pending cases that show up, because we know eviction is a major setback for a tenant. And what's worse is that if that shows up on your record when you were never actually evicted, it makes it harder to find new housing. We hope that going through this approach, we will help more people get back on their feet and be able to rent from better places, especially if they were never adjudicated to be evicted or that eviction was more than 3 years in the past. The package continues on the path that we started last year to continue to update Minnesota's landlord-tenant laws to bring us into the 21st century. This bill is the culmination of efforts from various housing advocacy groups, legal aid service providers, and Minnesota Multi-Housing Association. And so I'm grateful for the conversations we've had to get to this point and look forward to the floor debate tonight that will touch on additional provisions in the bill. Thank you, Speaker.
To the member from Isanti, Representative Johnson.
Madam Speaker, Representative Agbaje, I want to thank you for the work you've done on this, but unfortunately, we're going the wrong direction. With this DE amendment, we go from a 16-page bill to a 35-page bill. The 16-page bill that was brought over by the other body is the work of those same groups that was all agreed upon. There was peace in the valley. The 19 extra pages in the House file, that is the DE amendment that we're looking at, is not agreed upon. It's all one-sided. So as we go through this, I hope you will take some of the amendments that we have brought forward to try to make this somewhat better. So with that, we'll start with the amendments.
There being no further discussions, all those in favor of the amendment say aye. Those opposed say nay. The motion prevails and the amendment is adopted.
Madam Speaker, point of order.
State your point of order, Representative Nash.
Thank you, Madam Speaker. The DEA amendment has a $33,000 appropriation. There's a fiscal note that I had signed to have distributed. But because, as you'll look on the top of the bill, it was never sent to Ways and Means, because it has an appropriation in it, it cannot have skipped Ways and Means. So I would make a motion to refer it back to Ways and Means and request a roll call.
Representative Agbaje.
Madam Speaker.
Thank you, Representative Nash. My apologies. Yep. There being 15 hands, there will be a roll call. Representative Agbaje.
Madam Speaker, will Representative Nash yield for a question?
Representative Nash will yield for a question. Representative Agbaje.
Madam Speaker, could Representative Nash clarify what the fiscal note is referring to? Because if I think what it is, I have an amendment that clarifies that.
Representative Nash.
Thank you, Madam Speaker. Well, I have it here in my hand, and I believe it is being distributed. It is coded HF3591E, Landlord Tenant Rights Modified, and it is this fiscal note. And it says quite clearly there that it has a $33,000 fiscal note.
Representative Agbaje.
Madam Speaker, yes, I do actually have an amendment that addresses this fiscal note and so that there would not be a cost to it, and I believe that is the A25 amendment. I've had discussions with the Attorney General's office. If the A25 amendment goes on, they have agreed to absorb those costs.
Representative Nash.
Well, Madam Speaker, irrespective of whether you're putting on an amendment now, because when it moved, it had a fiscal note to it, it should have gone to Ways and Means. And that's just process. So we're bypassing process, I guess. So, Madam Speaker, would the Ways and Means Chair yield?
The Ways and Means Chair will yield. Representative Nash.
Thank you, Madam Speaker. Representative Olson, this has a $33,000 fiscal note that predates the A25 amendment that may or may not go on. We have to deal with the bill in its current engrossed format. So the DEA amendment is now what we have in front of us. Subsequently, we can't speak about things as if they may happen down the road, but we have to deal with it as it sits now. My referral is to send it back to Ways and Means because in its current condition, it has a $33,000 fiscal note.
Representative Olson.
Thank you, Madam Chair, or Madam Speaker. And Representative Nash, I'll just say that this is not the first time and probably won't be the last time. So just to clear up some confusion about what comes to Ways and why. So any bill that has fiscal impact in terms of like it's a policy as a fiscal, like we're talking about like metro mobility forecasting, that is a forecasted program. It has fiscal impact. Even if we're not appropriating, that bill would come to Ways. The House file you're talking about, aside from this fiscal note, has no fiscal impact. And the representative already explained that there's no appropriation in the bill. The AG has decided to absorb the cost, and I've talked with our House fiscal staff to verify that if we don't appropriate, if there is no fiscal policy or fiscal impact of the bill otherwise, the bill does not actually need to come to Ways. And so, yes, it has a fiscal note, but if we're not appropriating, there's no fiscal impact of this bill.
Further discussion. Representative Nash.
Thank you, Madam Speaker. I know Representative Garofalo is going to seek recognition here in a second, but members, I would refer you to page 4 out of 10 on the fiscal note. It is under the assumptions. It's the last two lines. It says the Attorney General's office estimates that it will spend 104 hours of attorney time and 156 hours of legal assistant time. So those are two different rates, and those are broken out for you in the fiscal note. I don't know how they absorb 104 hours and 156 hours of legal time. That's real salaries that we're paying to real people, and those account to real money. And it is not even, it's well above the de minimis amount. I had an amendment of mine ruled out of order, I don't know, 3 years ago, 2 years ago, it all runs together, that had required a $3,000 report that the department said that they could generate easily, but my amendment was ruled out of order because it was greater than the de minimis amount. This well past the de minimis amount. Just saying that you'll absorb something doesn't really absolve you from actually spending money on this. So it is very clear that money is going to get spent on doing these things. And whether or not you have the A25 amendment down the road to adopt, it may not go on. So we have to deal with the bill in its current format as it sits today. So I know that Representative Garofalo is interested in illuminating the conversation here in the chamber, but and I did request a roll call. Thank you, Madam Chair. Madam Speaker.
Further discussion on the motion. The member from Dakota, Representative Garofalo.
Thank you, Madam Speaker. And Representative Nash, thank you for bringing this to the body's attention. So I think if I understand right, this bill did not go to Ways and Means. Is that correct? And that this bill has a fiscal note in it, and we have from the Legislative Budget Office, we have a document here that says that it spends money. Whether the department or the Attorney General or really some guy standing out in a street says they're going to absorb the cost is irrelevant. And the fact of the matter is this spends money. This is why we have budget rules. Now, if we're going to have a new description of what spending money is, this would be an exciting decision by the DFL for this caucus going into the budget bills next week, that we can just proclaim whatever spending we want to have can be absorbed by the department. And we got a memo from the Assistant Committee of Irrelevancy telling us it's okay that we can do that. But I mean, the bill spends money. It's cut and dry. This is a 4.05 issue. It spends money. Didn't go to Ways and Means. It's got to go to Ways and Means. Game, set, match.
Further discussion on the motion. Behind you. Representative Petersburg.
Thank you, Madam Speaker. I'll just quickly say, so what we're doing here in regards to process, and I kind of really push for process. It'd be the same as when a police officer stops us for speeding and we say, yeah, but next time I go by here, I'm not going to speed, so therefore it should be null and void. You can't go backwards and reverse and then say, hey, we'll fix it even though we've stepped on the process. That's not right. This should go back to Ways and Means. Thank you.
The member from Stearns, Leader Damath.
Thank you, Madam Speaker. And Representative Nash, thank you for bringing this forward. And members in this chamber, I would encourage you to support the motion to re-refer. This is sloppy legislating. There is a full majority in this body that can do things on time. And as we've seen in the Rules Committee multiple times for the last 2 weeks, we are giving deadline waiver after deadline waiver after deadline waiver. This is sloppy legislating here in this body. Rule 4.05, amendment limits. An amendment to a bill that has received the second reading being considered the House is out of order. Well, I'm glad that there is actually an amendment that would fix this bill. But as this bill is before the body right now, it is not ready to be heard. This bill needs to be re-referred back to Ways and Means, get a confirmation that the Attorney General's office is going to absorb what we know from the fiscal note, hand it out to every member of this chamber. Let's get the confirmation, put the amendment on the bill in committee, and then bring a bill that is actually ready for the full body to vote on and give it a fair hearing. Please support the Nash amendment to re-refer this bill back to where it should be, and let's do better legislating for the state of Minnesota.
Representative Nash.
Thank you, Madam Speaker. So I've served on Ways and Means for a while now, I think 4 years, 6 years, something like that. And you know where we do this amendment that has money in it? The answer is Ways and Means. That is where we do these things. So that is where we can ask questions of the Attorney General's office. They'll send their legislative liaison, and we in Ways and Means can say, hey, Legislative Director, is this really going to be able to be absorbed by your department? Because, you know, curiously, 104 hours and 156 hours, that's not free. That's not just incidental staff time. That's not, hey, we have an intern that we're going to give a chuck on the shoulder and a nice certificate when they're done, and they'll be able to say, oh, it's all good. That's where we put this amendment on, Madam Chair, Representative Olson. That's in your committee, and you run a very good committee. This should have come to your committee because it spends money. It's just that simple. You have full control of the process. All we can do, as I've said in an interview, all I am is a Norwegian speed bump at times. However, this is what should have happened. Process matters. Process matters. It skipped the for some of our new members or for the 11 people watching at home, at the top of a bill, it will give you the destinations that this bill has hit. This bill, according to what's on top, was introduced on 2/13, adopted the report and referred to the Committee on Judiciary, or it went to Housing first on 2/13, that's where it was referred. Then it was sent to amended and sent to Judiciary, and then it was sent to the General Register. Well, that was a misstep because it spends money. So if you care one iota about process, even a little bit, if you've said process here at the Capitol, you should put up a green vote. It spends money. It didn't go to Ways. It can go to Ways. I'm making the referral right now. Members, vote green.
As a reminder, the motion before us is to re-refer Senate File 3492 to Ways and Means. A roll call has been requested. The clerk will take the roll. Members, please vote. Will the clerk call the names of the members voting remotely?
Carroll.
Here you go.
Carroll, no.
Carroll votes no. Daniels.
Daniels votes yes.
Daniels votes aye.
The clerk will close the roll. There being 62 yeas and 69 nays, the motion does not prevail. There's an amendment at the desk. The clerk will report the amendment.
Badge moves to amend Senate File number 3492, the third engrossment as amended. And the amendment is coded A25.
To the member from Hennepin, Representative Agbaje.
Thank you, Madam Speaker. This amendment is primarily a technical amendment, but I will go a little bit deeper considering the previous discussion we had. This amendment also gives authority to the Attorney General's office over the Chapter 504B, which is the chapter that deals with landlord-tenant relations. With this, they are able to step into this role should they need to prosecute a case, defend a case, and with that, they are willing to take on those costs with that expanded authority. In addition, the amendment has technical updates which matches enactment dates in the Senate, specifying that tenant organization activities are the ones that are protected, clarifying the language for the updated eviction process and remedies under covenants of habitability to make it simpler to understand, and again, the Attorney General's authority. So with that, I would ask for a green vote on the A25 amendment. Thank you.
Madam Speaker, point of order.
Representative Nash, state your point of order.
Madam Speaker, I rise under House Rules 4.05, amendment limits. We just heard that this is going to create costs for the Attorney General, not what we just talked, but it says that the amendment is going to give the Attorney General now even more ability to prosecute things. So it is going to create additional costs. Therefore, it has expanded the fiscal cost of the bill and is out of order. And I would be happy to have a discussion, but I hope others would rise to offer advice.
Advice. Representative Agbaje.
Thank you, Madam Speaker. There is no cost to this bill. There is no appropriation in this bill. Anything in here is really just what the policy is under 504B. The Attorney General's office has just asked for that additional authority to step in should they need to if a case arises. But that's only if they want to. Otherwise, there is no cost in this bill. There is no appropriation in this bill. And again, a fiscal note is just simply an advisory document.
To the member from Martin, Representative Olson.
Thank you, Madam Speaker. I'm very excited. We use this vocabulary word, absorb, right? We've talked about this vocabulary word multiple times here on the House floor. saying that the Attorney General's office will absorb this cost. Now, this is great news, members. And the reason why is because in the next couple weeks, we will be providing amendments to bills where we will determine there is actually no fiscal cost whatsoever. And we will be able to utilize the exact same argument that says we can have the agency absorb the cost. I'm sure there's someone sitting there that they're not working today or they're not busy, and we can have that person absorb the cost. They're still going to get paid their regular salary, and so this will have no problem with the bottom line. Members, this is actually really encouraging for those of us who kind of like to absorb costs. It's going to be really good. So, members, I'm excited to have this conversation. The utilization of the vocabulary word absorb will come up in the near future, I can promise you, if we in fact determine that there is no cost to this amendment. If in fact there is no cost, there will be many more amendments that have no cost, I can guarantee you. I love this vocabulary word, absorb. We shall see it again in the future, members. I'm looking forward to it. Thank you.
The member from Morrison, Representative Schultz.
Thank you, Madam Speaker. As some members of the body may remember, I brought an amendment just last week, and the point was raised at the time by the chair of the Ways and Means Committee that the word shall was something that would lead to fiscal cost. And as Representative Olson just mentioned, we're heading into the finance budget bills here coming up in the next few weeks. And this place can grind to a halt if we don't obey our rules. I think we've had this discussion before, and so, Madam Speaker, as you decide how to rule on this point of order, I hope you take into account not just what the rules say, but the impact that this could have to the debate the remainder of this session as we consider more Democrat, irresponsible, and unaffordable legislation.
Further advice to the member from Stearns, Representative O'Driscoll.
Well, thank you, Madam Speaker and members. I want to compliment Representative Olson and Representative Schultz. We're getting our spelling words and our vocabulary list together for our big test on, like I was in elementary school on Friday. You got the pre-test like on Tuesday, and then Friday you got the mastery test on those. Well, I'm going to throw two more words on the list: cost and expense. When we hear there is no cost to this, there is cost. What we don't have is money for the expense to cover this cost in the bill. I think it's very important if we want to be talking about shall and absorb and cost and expense. There is cost because money will be spent. We just don't have dedicated money from Ways and Means in the legislature, the appropriating body, to cover that cost or expense that will be incurred. So, members, I strongly encourage a support of the Nash amendment, or the Nash motion. It is something that we are going to be entering that season about where costs are. And I know that members on my side have some projects that they would like to see included that maybe didn't get included in some bills during the regular session. To be able to use words like, that has no cost, the agency can just absorb that, because that is great, great vocabulary. And I bet you we'll even be able to use the words shall in our discussions as well. So, members, appreciate your support, anticipating your support of this, or, if not, then we just throw open the doors to a lot of other opportunities to just have kind of a body of the whole, and we all get to be on Ways and Means all at the same time on the House floor. Thank you, Madam Speaker and members.
Further advice, the member from Wright, Representative Rarick.
Thank you, Madam Speaker. So this is something that we've talked about so many times in rules, or I should say I've talked about. And I honestly got really, really tired of looking at the path of these bills, but here we are again. Here we are again. And so this fiscal note was done on March 21st. Excuse me, March 20th. March 20th. The very next day, there was a hearing in Judiciary. So I'm looking at the minutes from the Judiciary Committee, and as the author of this bill said, well, the Attorney General said they could absorb the cost. Well, you know what? If that was the case, don't you think we would have talked about it in Judiciary? Guess what? There's no record of it. I'm looking at the notes right now. Nothing. Nothing. The fiscal note was done. The committee happened. There was no testimony from the Attorney General, because if there was, it would be in the record. There is nothing in the public record that the Attorney General came and said, oh, it's okay, we can, if you do this, this, and this, you'll absorb the cost. That didn't happen. This is a violation yet again of our rules, of our procedures. And we should care about that. I don't understand why we don't care about this. And I'm losing my breath. I've talked about this so many times in rules. Last session, I literally was sick and tired of looking up bills and saying, it missed process again. And here we are again, and here's yet another bill. And I thought really, I thought you guys had pulled it together, because as I was looking through this year's bills, it was better. But here we are again. This discussion needed to happen in judiciary, and this discussion needed to happen in Ways and Means, and it didn't happen either place. This fiscal note was ready. There should have been testimony to it that if the Attorney General was going to absorb costs, if this whatever was done, that should have happened in judiciary. This bill really needs to go back to judiciary and have that conversation. I would go back to Ways and Means, because we have those experts on that committee as well. There's a reason why you've got the top committee chairs and your top leads on Ways and Means. There's a reason for that. This is the reason. This is a gross violation of our rules and our procedures, and this has to go back to at least Ways and Means, but I would argue, like I said, back to judiciary, and actually have the Attorney General come and discuss it in full. And Representative Scott can fully vet it, because she is very keen and very aware of all of that, and sharp. She is a very sharp person. So I would implore you to send this back to Ways and Means. Please, let's do this correctly. We haven't done, last session was absolutely horrendous. I can't tell you how many bills violated our rules and our policies, and here we are again. Members, this is too much. Send it back.
The member from Carver, Representative Nash.
Thank you, Madam Speaker, and I'll give you further advice. I sort of anticipated that we might have this part of the conversation. So to riff off of Representative O'Driscoll, he stole my thunder a little bit, but I didn't pass out copies of this because I didn't want to kill that many trees, but I have a fiscal note for Representative Bonner's House File 2257 in my hand. In there, they outline what the cost of those two staff attorneys and researchers, $163 an hour for an attorney. Legal assistant is $103 an hour. Then we'll move over to Representative Elkins' bill, House File 2309. Very similar to what Representative Bajaj is trying to do with the A25. There is a $98,000 fiscal note for doing the same thing. Then we'll go to Representative Bierman's bill. It is House File 402. That must have been introduced early. It's a very low number. But here's what the assumptions were in that fiscal note. It says, the Attorney General's office will require additional staff in its Consumer Wage and Antitrust Division, Charities Division, devoted to a new investigatory and enforcement provisions. We just heard that the ability for the AG to investigate some of these things is now being added in with the A25. So don't confuse what I just rose to a point of order on. We're now on this new amendment on the A25 point of order. It is expanding, Madam Speaker, it is expanding the AG's purview. I've provided the fiscal note example of this bill and 3 other ancillary fiscal notes, all stating very clearly that when you expand the ability of the AG, you are creating an expense. Because you are putting fiscal impacts into the bill now, it has to go back to Ways and Means. It is out of order under 4.05, and we've debated these before. And Madam Speaker, I hope that unlike Angel Hernandez, the least favorite umpire in the entire Major League Baseball, that you, Madam Speaker, have a fair strike zone, because it is clear, it is incontrovertible. Call a strike, a ball, a ball. You have time. Ways and Means always meets at the discretion of the chair. And Chair Olson is a friend. If she said, hey, Jim, we got to come back to Ways and Means to do the thing that you talked about on the floor, I'll go. The entire Ways and Means Committee will go. We'll have a conversation. You still have the votes, but you've bypassed process. And I would point out, much like Representative Rarick, I will get Rarick, it'll just kind of come off my tongue. She talked about that the AG's office did not testify. You know where else the AG cannot bring us a message? Here on this floor. The AG has no ability to come in and lift up a microphone and get recognized at all, Madam Speaker. Please, in the name of process, let's hold on to the thinly veiled fealty that we have to process and do the right thing.
The member from St. Louis, Representative Olson.
Thank you, Madam Chair, or Madam Speaker. So everything I said still stands from the previous part about why a bill does or doesn't go to ways based on the appropriation. That aside, I believe, and there was some confusion under here, and we're trying to understand, you rose to a point of order under the A25 amendment, which does the fiscal note that you passed out has nothing to do with the A25 amendment. There is no cost, there is no fiscal note, there is nothing to do with the A25 amendment, which you're rising to. Second piece that I talked with Chair Howard and confirmed, the DE substantively changes the bill from what the fiscal note was noted on. So Representative Nash, the fiscal note that you're noting, the bill has substantively changed with the adoption of the DE that we just adopted. The fiscal note is not on the language that we just adopted. So for multiple reasons, I do not think you should find the point of order well taken.
This will be my last bit of advice from the member from Stearns, Representative Damath.
Thank you, Madam Speaker. I just want to point out to this body that we are, again, being irresponsible in this body. When we say that there is no cost or the Attorney General's office can just absorb it, I just want to remind the body and anyone in Minnesota that may be paying attention to what is happening here in this chamber right now. Previously, we had funded the Attorney General at $54 million. Last year, we increased that. We are now funding the Attorney General's office at $96 million. Of course, they can just absorb it, which is ridiculous. We are being gaslit in the state of Minnesota. I want to bring people's minds back to January of 2023. We had an $18 billion surplus in the state of Minnesota that was spent. And not only was it spent, everyone in Minnesota was going to get $2,000 checks, and we were looking forward to that. But we waited a little bit too long, spent all of the money, and returned $260 checks to some Minnesotans, and we couldn't get that done on time, so those Minnesotans are being taxed at this point. Another broken promise by this body, the majority in this chamber, full repeal of the tax on Social Security for our Minnesota seniors. But wait, we had to means test that, and then we didn't do a full repeal on the
Representative
state.
Long, state your point of order.
Leader Damath knows that she's very far afield from giving you advice on the motion at this point.
Leader Damath.
Thank you, Madam Speaker, for allowing me to continue giving you advice on this point of order. That is very much appreciated. In this body right now, I would request that you would vote to take the point of order brought up by Representative Nash and support that point of order. We are out of order on this bill. We are out of order on this amendment. And we are doing, again, sloppy legislating here in the state of Minnesota. We can do better. Send this bill back is what we should have done. This amendment is out of order, as you have heard from our rules, and I would ask that you would vote to support the point of order that is made by Representative Nash. Thank you, Madam Speaker.
Madam Speaker, parliamentary inquiry.
Representative Cree shall state your parliamentary inquiry.
And Madam Speaker, according to the rules we've adopted, the permanent rules, what is the purpose of the Ways and Means Committee?
Representative Kresha, are you looking to maybe ask that question to Representative Olson?
No, Madam Speaker, I'm asking you, parliamentary inquiry, according to our rules in the Article 6 Rule Committees and Divisions, what is the purpose of the Ways and Means Committee? Why does it exist?
Representative Kresha, that is a question that is not for me to answer. That is actually something that Representative Olson can, but I'm actually at the point of which I'm going to rule on the point of order by Representative Nash. And so I would like to move to that point of order from Representative Nash. I have studied the amendment. I have reviewed the bill. I have considered your advice, and I have a ruling, and that I find the point of order is not well taken.
Madam Speaker, point of order.
Representative Nash, state your point of order.
Madam Speaker, I would appeal the ruling of the chair and request a roll call.
Representative Nash appeals the ruling of the speaker and requests a roll call. Seeing 15 hands, there will be a roll call. Representative Nash.
Thank you, Madam Speaker. Well, Chair Olson, I did state that there were three three fiscal notes that were not this bill, and they each are doing the same thing that Representative Agbaje is doing in her A25. I'm not referring to the previous fiscal note. I'm referring to these other fiscal notes. They are giving the AG additional abilities that Representative Agbaje just said she was doing. They do incur an expense. Therefore, Madam Speaker, here's your chance. Here's your chance to do the right thing and actually respect process. We have the ability to send this back to Ways and Means if you rule for process. So it's very simple. Either process matters or it doesn't. And I'm happy to walk these other fiscal notes over to the Ways and Means chair if she'd like to give them a gander, because they do exactly what this A25 amendment will do, which gives the AG's office additional abilities, which incurs an expense. So I would urge members to overrule the finding of the speaker. Here's your shot, because I believe, naively, perhaps when I was getting elected in Carver County, I was under this naive assumption when I got here 10 years ago, that process, matters. But in the last 6 years that I've been in the minority, I'm learning that maybe it doesn't. Madam Speaker, you have a chance to be convinced of your ruling of just a couple minutes ago, but a lot can change in that time. We can realize that simply sending something back to committee to check a box, you've got the votes, you can outvote us, but in upholding the ruling of the speaker, when you all vote for that, you are effectively saying you don't care about process.
To the member from St. Louis, Representative Olson.
Thank you, Madam Speaker. The point of order and the ruling of the speaker were very well taken, and we should support the ruling of the speaker. Representative Agbaje was very clear in describing the A25 with her amendment in lines 4.19 through 4.24 with the 8.31 section authority. It's substantively different than whatever Representative Nash is talking about. This underlying amendment did not have a cost, and you ruled correctly, and I invite the body to support your ruling, Madam Speaker.
The member from Morrison, Representative Kresha.
Thank you, Madam Speaker. And so as I asked the question, members, we adopt the permanent rules of the House. And in here, I'll answer the question that I asked under 4.03. The Committee on Ways and Means must hold hearings as necessary to determine state expenditures and revenues for the fiscal biennium. Seems pretty clear that's what we're doing. I don't know how to make, if Ways and Means doesn't exist to do that, then why do we have it? Then why do we have rules for the House? Why do we have committees and divisions? So I will read that again. The Ways and Means Committee, the Committee on Ways and Means must hold hearings as necessary to determine state expenditures and revenues for the fiscal biennium. I suppose the wiggle room here is as necessary, which appears to be shucks whenever we think. So perhaps we could just follow the rules that we've adopted, and Madam Speaker and members, I would rule against the speaker on this, and let's follow our rules.
Member from Martin, Representative Olson.
Thank you, Madam Speaker. It was a couple of weeks ago in the Tax Committee when the Ways and Means Chair explained to, I believe it was Representative Robbins, the fact that even if you design something that says there's no fiscal cost, if you're having someone do something, there is in fact a cost to it. That was explained to us in the Tax Committee by the Ways and Means Chair. Now I'm impressed and interested to see that today we're hearing the opposite comments being made, which is interesting because this could completely and utterly shift my personal understanding, but in the entire House of Representatives' understanding of determining that other people are going to do work, and this vocabulary word of absorb. I'm really interested to see how we set a new precedent here in the House of Representatives saying, 2 or 3 weeks ago, if you need someone to do work, there's a cost to it, regardless of what this piece of paper says. If the piece of paper says 0 or it can be absorbed, anytime you're asking someone to do work, you do in fact incur a cost. That was a statement that was made in the Tax Committee. I remember it distinctly. But then this exact person is now telling us what I said 3 weeks ago, not true. Just kidding. What I'm saying right now is true. That's what is being said. And that's okay because I'm inclined to vote in line with the Speaker's decision. Because you all know that I so enjoy these little kerfluffles that happen on the House of Representatives floor. And this will just open up so much fun in games, which may in fact be irresponsible. So I think I just made up my own mind. I know I can't ask anyone else how they're going to vote, but I think the responsible thing to do here would be to send this back, to identify that, yes, we made a mistake. It's okay. Everyone makes them. Everyone makes mistakes. We can say, let's do the right thing. Let's do it. We'll fix it. We'll bring it back. And then the majority can pass it like they plan on doing. But if they choose not to, if they choose to say, never mind to what I said 3 weeks ago, only mind what I say now, first of all, I then question that person's integrity as to, tomorrow, are they going to change?
Madam Speaker, point of order.
Oh, I can't
point of
question.
order.
Representative
That's right.
Olson,
You
state your
cannot
point of
arraign
order.
motives on the House floor. Representative Olson knows exactly what he is doing.
Motives.
Trying to test my character in what I said 3 weeks ago, and then questioning my integrity is clearly about motives.
Representative Olson, please confine your remarks to the topic at hand and not arraign motives.
Interesting. I guess I don't make that connection, but that's okay. I'll let it go. I think that we need to do the right thing. We need to follow the rules as they are written, not as we say they are. They're written for a reason. We should uphold, not uphold. We should say no, because, I've made that decision. I was thinking about upholding the ruling of the Speaker because I think it'd be fun. That's irresponsible. Let's overturn the ruling of the Speaker. Vote red, please.
The member from Isanti, Representative Johnson.
Madam Speaker, members, we need to overturn this ruling of the Speaker. As Representative Krisha said, this is an expense. Ways and Means needs to hear something that deals with expenses. Now, the amendment strikes one area that costs $33,000 to the Attorney General's office. It removes that. But guess what? It gives more authority and more responsibilities and more duties. So it's more than $33,000. We don't know. We need a fiscal note to find out how much it is. It could be $200,000. We don't know. The ruling of the Speaker needs to be overturned, and this bill found in violation of the rules because there is an expense. Members, vote to overturn the Speaker.
The member from Wright, Representative Rarick.
Thank you, Madam Speaker. I never speak on this stuff. You remember Mary Liz Holberg? When Mary Liz Holberg would get up and speak, it meant that something was really important, that it was real, it wasn't just political speak. And, as Representative Horenstein is retiring, he said to me in my freshman year, and you guys that have been around a while will appreciate this, do you want to be a Drazkowski or do you want to be a Mary Liz Holberg? I believe I've chosen the path of Mary Liz Holberg. So I am not making some political crazy speech. I'm telling you that there is something sincerely wrong with this. Please listen. I'm not going to arraign any motives or anything. I'm not going to attack the Ways and Means Chair. I will never do that sort of thing. I don't do that. But I will tell you, if you turn to the amendment, and you've all got the amendment packages, the last page of the amendment package, it says, yes, we are striking some language and some responsibilities for the Attorney General, but we're also saying that the Attorney General has authority under Section 8.31 to investigate and prosecute violations of this chapter. And it goes on from there. We are adding significant additional authority to the AG's office to investigate and prosecute. That is work. That is cost. This amendment costs money. You might be taking, in fact, you know what? Even if you got rid of this entire fiscal note, which I don't know because we don't have a revised fiscal note, because you know what? If we were in committee, we would have an amendment, we would have a revised fiscal note. That's process. That's what we should be doing. We're not doing any of that. We should not be doing this on the House floor. We shouldn't. It should be done in judiciary, if you're, like I had said before. But I would take doing this in Ways and Means. But we should not be doing this on the House floor. We need a revised fiscal note. So if we're going to be doing a substantial amendment, which is what this is, and giving substantial new authority to the Attorney General's office to investigate and prosecute sections 8.31 of this chapter, that's people, that's work, that's money. That's a cost. I don't have a revised fiscal note in front of me. I don't have a letter from the Attorney General. I don't even have a letter from the Attorney General, members. If I had a letter from the Attorney General, I might be less likely to stand up and talk about this. But in the spirit of Mary Liz Holberg, I implore you, please, let's do the process and let's do it correctly. Thank you, members.
The member from Sherburne, Representative Lawrence.
Madam Chair, thank you. This is my first time to address the House, as I've shared. I'm 10 days in at this point in time, and I've listened to issues through the last couple of weeks, and this is one I wanted to speak on today. And I just want to mention I'm grateful to be a part of this great body and the decisions we get to make. And so just honored to be here and be a part. As we speak regarding the issue at hand, last night, and I think all of you received it. I don't think I was singled out, but the Speaker of our House sent out a memo, sent out a letter citing rules. Setting rules of how our chamber is supposed to operate, going back to rules. I noticed differences because we read them. I read all of them. I was grateful to get them. It was something I hadn't seen before, and so I read through it. But she intentionally set it out to cite the rules on how we are to operate. Tonight we're talking about rules. We're talking about rules about a single bill, an amendment that's before us. And my request tonight is, let's just follow our rules. I know I'm new, I know I haven't been here a long time, but as I look at it, I just ask, let's follow our rules, as the Speaker has asked us to do in the memo last night. Thank you.
The member from Anoka, Representative Niska.
Thank you, Madam Speaker. And I was wondering if Representative Agbaje would yield to a question.
Representative Agbaje will yield for a question. Representative Niska.
Thank you, Madam Speaker. And Representative Agbaje, Chapter 504B doesn't currently have any. Does the Attorney General currently have authority to do any enforcement under Chapter 504B under existing law?
Representative Agbaje.
Thank you, Madam Speaker. Thank you, Representative Niska. This is to allow the explicit authority, but there is implicit authority through another statute that's focused on commercial laws.
Representative Niska.
Thank you, Madam Speaker. And Representative Agbaje, I think you might just be referring to 8.31 as it already exists, which I think there's some uncertainty as to whether or not the Attorney General would have the authority to enforce 504B under that. This does open an entire chapter of Minnesota statute to Attorney General enforcement. And as Representative Agbaje, you, I'm sure, are aware, as many of the members of this body are aware, as anyone who's ever hired a lawyer is aware, lawyers taking cases, that's not free. Costs money. So when we write into a new statute that the Attorney General's office now has authority to enforce an entire new chapter of Minnesota law, I think that's probably going to cost some money. At the very least, it's worth inquiring through the Ways and Means Committee, through the State and Local Government Committee, maybe through the Judiciary Committee, what that's going to do. But if we're just amending new enforcement mechanisms into statutes on the floor, and we're not even willing to say, well, that new agency that we've just given enforcement authority to, we're not willing to have some sort of inquiry as to what kind of cost is involved in that? Come on. What are we doing here? Do you really want to go into this with, 17 legislative days left? Do you really want the next 17 legislative days to be, as we talk about budget bills, do you really want this to be the precedent that you set? Do you really think you're going to pass budget bills in the next 17 legislative days, if this is the precedent that you set? Think very, very seriously about that question. Think very seriously about that question. Because what we're doing right here is we are taking a state agency that we fund, that the funding should go through the Ways and Means Committee, and we're just opening up an entire new chapter of Minnesota law to enforcement by that agency. And we're not going to send it to the Ways and Means Committee to look at the expenditures that are going to happen there? Members, think about what you're doing for the next 17 legislative days that we have left. If you think we're going to pass budget bills and then conference committee reports, think seriously about the precedent that you're setting and the implications of that precedent. Please vote to overturn the ruling of the Speaker.
The member from Stearns, Leader Damath.
Thank you, Madam Chair, or Madam Speaker. And before we actually vote on the appealing of the ruling of our Speaker, this goes far beyond the bill that is in front of us, but this goes to the integrity of the work and the process and following the rules in this place that we have in front of us. We know that we had a fiscal note of $33 million. I'm sorry, $33,000. We know, here in this body. We also know that on the A25, line 419 through 421, it says the Attorney General has authority under Section 8.31, as you've heard from Representative Niska, to investigate and prosecute the violations of this chapter. Madam Speaker, would Representative Agbaje yield for a question?
Representative Agbaje will yield for a question. Representative Damath.
Thank you, Madam Speaker. And Representative Agbaje, could you tell me what in 4.19 through 4.21 would make it optional for the cost that the Attorney General's office is going to be incurring on this?
Representative Agbaje.
Thank you, Madam Speaker. Thank you, Minority Lead Damath. The Attorney General's office can decide, or if they are asked, to come in and look at a situation. They already do this now. If we remember the Havenbrook homes, that was something that they decided to take on their own. What they are looking to do is ensure that in this context of commercial law between landlords and tenants and the contract law, that they're able to step in if necessary. But that is for them to decide. This is not mandated for them to step in.
Representative Namath.
Thank you, Madam Speaker, and thank you, Representative Abaje, for that, that answer. I appreciate that. You know, when I look at what we are doing here, there is going to be a cost. It's either in the fiscal note or it's in this amendment. I see a cost in this amendment, and if there is not, we have no guarantee that there isn't going to be a cost. So either it will have a cost, or what I'm hearing is that no one is going to violate these laws and need proceedings held against them, and I don't really think that is the case. I would ask you, Madam Speaker, to please reconsider your ruling for the time, both in this and what we're doing here, on this procedure, not on the bill, but on this procedure, or I have grave concerns about the rest of the days that we have in front of us. What are we on? Day 103 out of 120. We have 16 days left. And we have a lot of omnibus bills, not just budget bills. We have omnibus bills coming forward. If this is the precedent that we are setting in this body, and we know we do our work based on both rules, but then the precedent of how they are interpreted, I have grave concerns about those days going forward and how we're going to be doing this work. Madam Speaker, I would ask that you would seriously reconsider the ruling that you have made. Let's take a pause on this and do the right thing in order to hold up the integrity of the work that is done here in this body. Thank you, Madam Speaker.
As a reminder to the body, the question before the body is, shall the decision of the Speaker stand as a judgment of the House? A yes or a green vote supports the ruling of the Speaker. A no or a red vote goes against the ruling of the Speaker. A roll call was requested. Therefore, the clerk will take the roll. Members, please vote. Will the clerk call the names of the members voting remotely?
Carroll.
There you go.
Carroll, yes.
Carroll votes aye. Daniels.
Daniels votes no.
Daniels votes no.
The clerk will close the roll. There being 69 yeas and 62 nays, the judgment of the House that the decision of the Speaker shall stand. Back onto the Agbaje amendment. The A25. Discussion to the A25. There being no further discussion on the A25 Agbaje amendment, all those in favor of the amendment say aye. Aye. Those opposed say nay. Nay. The motion prevails and the amendment is adopted. There's an amendment at the desk. The clerk will report the amendment.
Dodseth moves to amend Senate File Number 3492, the third engrossment as amended. The amendment is coded A14.
The member from Carlton, Representative Dodseth.
Thank you, Madam Speaker. Members, my amendment's a real simple amendment. What I'm looking to do is amend and basically just amend page 13 through 15, delete sections 2 through 5, amend it as follows. Basically to delete and eliminate the language that's in there right now that allows a housing provider the ability to deny rental applications based on past pending evictions, actions, and or court filings. What that means is if you've got someone that has past evictions, you can, the current language in there doesn't allow you to actually evict or eliminate them. I would ask that if you were to actually be forced to rent your current property out that you own right now and become a housing provider,
Would that be something that you'd want to do, is actually not be able to screen your tenants and verify if there are any evictions or any issues on their record? You know, at the end of the day, housing providers depend on a business platform that allows them to make sure that they pre-screen their tenants and make sure that they're qualified, that they can pay rent, because their business model is not a nonprofit. It's actually a for-profit industry. This provision is to protect the tenants and others that are also in the units as well. Currently, there's language in there that would force you to actually rent the unit to someone that might have criminal activity. I would also ask you, would you, if you had a duplex and you live next door and you have a family member on one side, you're forced to move out of your unit, would you want to at least have that choice of choosing who's going to be able to live in that unit next to them, that they've been properly vetted? I would sure hope so. You know, the concern you've got is if you've got unsafe activity where individuals are selling drugs, doing illegal activity, you should be able to pre-screen and make sure that these tenants have been properly vetted. I would ask that you consider this amendment. This is a good amendment. It's a reasonable amendment. I thank you.
The member from Hennepin, Representative Agbaje.
Thank you, Madam Speaker. I would urge the body to vote no on this amendment. We need this provision as a mechanism to protect tenants from the stigma of eviction. That's why it was written. What this section actually does is when a landlord is screening for tenants, we want to make sure that they're not only using the fact that a person may have a filing of an eviction on their record and then tossing out that application. We want them to do a full review of the application. Additionally, another part of the section that is being sought to be deleted also works with tenant screening agencies, that they are providing the most up-to-date information about what is on a person's record should any court proceedings show up on that. So again, this effort is really to better ensure that landlords understand the filings that they're seeing from the tenant screening agencies, and also helping to make sure that people can get back on their feet if they have had a setback in their housing. And so we really do need these provisions in the bill, and so I would urge the body to vote no on this amendment. Thank you.
Further discussion on the amendment. Actually, I'm going to go to the member from Isanti, Representative Johnson.
Madam Speaker, members, Representative Dosseth, thanks for bringing this forward. I do have to agree a little bit with Representative Agbaje, but she's forgetting a very important part. Evictions aren't just for non-payment. You can get evicted for damaging property, for not and causing safety issues for the other tenants in those buildings. There's many other things that you can be evicted for. Selling narcotics on the property, sexually harassing people, committing crimes on that property, violent crimes. That's what's also in those eviction papers. That's why they need to be seen. What type of eviction are they doing? That needs to be known, and that should be looked at. Because a property owner and the housing provider is liable for things like that if somebody gets hurt, because a person is there because they didn't do their due diligence to make sure of who's coming in there to rent. And if they rent to a violent person that can cause injuries or death, that housing provider can be held liable. Thank you, Representative Dotheth. Please support this amendment.
The member from Morrison, Representative Creshaw.
Thank you, Madam Speaker. And I'm wondering if Representative Johnson would yield for a question.
Representative Johnson will yield for a question. Representative Creshaw.
Thank you. And you went through a long list of evictions, and thank you about all that. And I'm wondering, about 3 weeks ago, I had sent a letter about me not leaving my office because constitutionally my constituents need a place to meet. Would any of those grounds be eviction to make me move out of my office at the current Senate office or state office building?
Representative Johnson.
I would have to say, I'm not sure that was, because that is not a residency. This is dealing with the homes and residents of homes. Your office is not a home, so I'm not sure how that would work.
Representative Kresha. Representative Dotseth.
Thank you, Madam Speaker. As I mentioned, this is a reasonable bill, and I will request a roll call on this. This is just a common sense.
A roll call has been requested. Seeing 15 hands, there will be a roll call. Representative Dotseth.
Thank you, Madam Chair. If we really care about the best interest of all the people in these units, I believe Representative Johnson covered that properly back there. We need to make sure that the people are properly vented when you're actually renting the unit to the people. And I think we really have to look at making sure that the pre-screening that's done adequately. So I encourage a yes vote today. Thank you.
There being no further discussion, the clerk will take the roll. Will the clerk call the names of the members voting remotely?
Carroll.
Here we go.
Carroll, no.
Carroll votes no. Daniels.
Daniels votes yes.
Daniels votes aye.
The clerk will close the roll. There being 62 yeas and 69 nays, the motion does not prevail and the amendment is not adopted. There's an amendment at the desk. The clerk will report the amendment.
Dotseth moves to amend Senate File Number 3492, the third engrossment, as amended. The amendment is coded A15.
To the author of the amendment, the member from Carlton, Representative Dotseth.
Thank you, Madam Chair, members. This amendment, again, is another real simple amendment. Page 16 deletes Section 2. What I'm looking at doing, this language basically brings forward the possibility of potential misuse of the policy by the tenants and concerns that the quality of repairs along with the financial operations and challenges of the landlord. Critics argue that such provisions could lead to unnecessary or overly expensive repairs, despite over the natural cost of repairs and strain of landlords-tenants relationships. This provision has potential complications related to liens related to work done by the contractors of these units, et cetera. I think we really have to make sure that what this does is it allows tenants to order repairs to be done to a property without the landlord's consent. That's just, I request that you vote no, or vote yes for my amendment. How's that? But vote no on the bill. How's that?
Member from Hennepin, Representative Agbaje.
Thank you, Madam Speaker. I was hoping there was some support there, Representative Dotseth, but I guess not. I would encourage members to vote no on this amendment. Again, Representative Dotseth is seeking to delete a section of the bill that's actually very important. This provision lays out a simpler method for tenants to address repairs when a landlord has been unresponsive to the needs of the property. And so this is necessary if you have an absentee landlord or someone who just is not responding to your text, your emails, your concerns, and we shouldn't allow tenants to just wallow in a state of disrepair. This is actually really helpful to tenants because those who live in units that repairs could be done on their own, like lawn care, porch or deck repairs, window repairs, or change of a non-working appliance. And also, it's not an opportunity for a tenant to upgrade their unit. They actually, and according to the bill, they actually would need to do something that's of comparable cost and that meets what was already in the unit. Any updates to the unit also remain with the landlord when the tenant is out, when the tenant moves out. And there's also a number of provisions in the bill too, actually based on our conversations, that require notice to the landlord, that require a potential inspection, and that also require you that if you contract the bid out, you contract to someone who's not related to you. So we have a number of provisions in there to make sure that a tenant, if they are going to embark on a repair, that it's done in a comparable way, and that the landlord is fully aware of the process, so that way the price of the repair can be deducted from the rent appropriately. So I would continue to urge members to vote no on this amendment.
Further discussion on the amendment. Representative O'Driscoll.
Thank you, Madam Speaker. And a couple of things. Professionally, I get into these topics quite a bit with the real estate work that I do, the insurance work that I do, the appraisal work that I do, and contractor area. And when I saw this bill, I had some questions that came to mind. I'm just wondering if the bill author would be willing to answer a few questions, help me get some clarity on a few items.
Are you asking Representative Agbaje to yield? Representative Agbaje will yield. Representative O'Driscoll.
Thank you, Madam Speaker and Representative Agbaje. The first question that I have is there a minimum number of units, contiguous units, that this proposed bill applies to?
Representative Agbaje.
Madam Speaker, Representative O'Driscoll, it only applies to the unit that the tenant lives in.
Representative O'Driscoll.
Okay, well, thank you, Madam Speaker. Representative Agbaje, for seeking further clarification, you said it only applies to the unit that the individual lives in. So it doesn't, let me just give you an example. I'm not saying that this is what the bill says. It applies to properties with 12 or more units. It applies with a property that has 8 or more units that are available for rent. What's the minimum number of units that this proposed law would apply to?
Representative O'Driscoll, are you asking Representative Agbaje to yield again?
I am.
Representative Agbaje.
Thank you, Madam Chair. Thank you, Representative O'Driscoll. I think I now understand the premise of your question. I mean, it would apply to anyone who's renting out a unit to someone. So if a tenant is living in that unit and they make a repair, should this go through, they would have the ability, if following the process of a 14-day notice, doing inspection, bids, all that, they could do the repair.
Representative O'Driscoll.
Thank you, Madam Speaker. Representative Agbaje, the reason I asked that question is that we have exceptions where laws apply, particularly if the tenant lives in the same unit in a single-family home or the tenant is renting a room. And I'm wondering if your proposed legislation would apply to a homeowner who is opening up their home to bring someone in to rent a room. Would this particular proposed legislation apply to that homeowner who's renting a room in their own home?
Are you asking Representative Agbaje to yield?
I am.
Representative Agbaje.
Thank you, Madam Speaker. Thank you, Representative O'Driscoll. I mean, I believe it would apply. I would hope that in that type of situation, there's more conversations happening, and hopefully they can work on it together. But if not, and there's a repair that the landlord or the owner-occupied landlord is not addressing, the tenant should have the ability to engage and make those repairs.
Representative O'Driscoll.
Thank you, Madam Speaker. And Representative Agbaje, under Minnesota statute 363A, which is the Minnesota Human Rights Act, in real estate, it exempts a owner-occupied single-family home from a lot of different regulations under the Human Rights Act. But yet in this particular piece of legislation, you're saying that it does include the homeowner who's renting out a room in their own home. And the reason I asked that question is this could apply to just about any property, but it could apply more likely to someone who's renting out a room in the residence that they occupy and own, and that's got to be both, occupy and own as their primary residence. And here's the problem. Mail will most likely come to both the tenant and the homeowner who is renting out a room in their home. So the system could be gamed in a situation like this where the tenant wants to have some kind of a repair done in the property and the landlord is quote unquote unresponsive to the tenant's request. So the tenant invites a contractor to come to the property to make the repairs. And under Minnesota statute 514.011, which is the Minnesota mechanics lien statute, a notice has to be provided by anyone who provides skilled labor materials for the improvement of that real estate to give a notice in writing no later than 10 days from the time you enter into an agreement for services. So you look at this and you say to yourself, well, the notice could have been sent to the address. An occupant in that property could have intercepted that communication, where the homeowner who is renting a room in that home to a tenant would have no idea whatsoever that they have been served a lien notice, because the statute calls for the method of delivery under 514.011, which is the actual physical statutory notice, that it needs to be delivered either personally or via certified mail. And it can be received by the owner or a designated agent of the owner. And a designated agent of the owner might be a property management company or something along that line. So an unsuspecting homeowner who is probably an elderly person or a young person who bought a home and is trying to make payments on that home, renting out a room for extra income on either end of the spectrum, may have a mechanics lien placed on their home as a result of work that was ordered by a tenant that the homeowner wasn't even aware of, because of the form of living arrangement and no exception to protect the homeowner. So why does that become a problem? Well, that homeowner wants to go and refinance that home. They now have a lien on the property that they have to pay. They're responsible for paying that. And that tenant may have moved out. That homeowner may be unsuspecting, not a big corporation, not a big mega housing provider that I think this bill is trying to go after. It goes after the mom and pop operation equally as it goes against the mega corporation that may own housing units. Representative Dotseth, thanks for taking care of the small homeowner who's just trying to make ends meet by renting a room in their home and not making them and others subject to the issues under this statute or proposed language. And that young professional who's going to take a shot at buying the American dream, buying a home, and rents out a room to try to help cover the expenses. It's nice to know that you've got their back, and I would encourage a yes vote on the Dotseth amendment. Thank you, members, and Madam Speaker.
The member from Isanti, Representative Johnson.
Madam Speaker, members, Representative O'Driscoll, thank you for explaining that. Because property owners need to know what's being done on their property to make sure it's done properly and to code. There could be somebody that the tenant hired to come and do a little bit of electrical work, just got off apprenticeship, got their license, or they're not even doing anything with electrical, but they happen to cause some electrical issues. So who's liable? We don't know. The owner of the property, the housing provider, probably didn't even know any work was done. Yet there could be a fire and his property is destroyed. I also know what it's like to have a mechanics lien. Years ago, when my father-in-law built his new building for his bowling center, we paid the general contractor, who paid the subcontractor who didn't pay for the materials. Guess who got the mechanics lien? My father-in-law. Even though he paid for it, he still got the mechanics lien, and we had to go to court to get that settled and verify that we paid the money. The general contractor had to verify that they paid the subcontractor. After quite a few dollars in legal fees and a lot of time, we got it resolved. But it did cost quite a bit. So, Representative Dosseth, thank you so much for this amendment. It's important. It's important that whoever's doing the work in these buildings, whether it's a single family home that's have a bedroom rented out, or a mega complex owned by a nonprofit, we need to make sure that the work is done properly. And in those large properties, guess what? They have a maintenance contract. And if the tenant has somebody in there that's not part of that contract, it's a violation of the contract. It can cause other illegal issues. Please support the Dosseth amendment. I understand why Representative Agbaje is doing this, but it needs to be a lot more work to get it right. And going to conference committee or on the floor is not the place to get it right. It needs to be done in committee. Please vote for the Dosseth amendment.
Representative Dotseth.
Madam Chair, members, I would encourage a green vote. I would request a roll call, please.
A roll call has been requested. Seeing 15 hands, there will be a roll call. Seeing no further discussion, the clerk will take the roll. Will the clerk call the names of the members voting remotely?
Carroll.
There you go.
Carroll votes no.
Carroll votes no. Daniels.
Daniels votes yes.
Daniels votes aye.
The clerk will close the roll. There being 61 yeas and 69 nays, the motion does not prevail and the amendment is not adopted. There's an amendment at the desk. The clerk will report the amendment.
Nash moves to amend Senate File Number 3492, the third engrossment as amended, and the amendment is coded A16.
To the member from Carver, Representative Nash.
Thank you, Madam Speaker. The A16 is indeed my amendment, and I would request a roll call.
A roll call has been requested. Seeing 15 hands, there will be a roll call.
Thank you, Madam Speaker. The A16 would remove the portion of the bill that provides for tenant associations to have organizers come into the building. And the principal reason for that isn't because I'm trying to not allow someone to organize. It's because the request that we made, I think 2 times in committee, for there to be one piece of language added in to ask for those organizers to be to undergo a background check. Now, I know that the DFL majority loves background checks. That last year you passed universal background checks for guns, and I thought, once again, potentially naively, I thought that a background check for somebody who is going to be invited into an apartment building with the specific intent of organizing should at least stand the test of a background check. Now, in committee, we heard, well, these are good people. They don't need to. They're known quantities. Well, then I got the answer of, well, not always known quantities. So on the very fact that they are not all known quantities, what's the harm? What's the damage in saying, hey, person who's going to be going in there to organize, you should, before you do so, undergo a background check? If they are truly benign human beings and they've got nothing but love and charity in their heart, then we should have no problems, no qualms with them undergoing a background check. So I'm going to ask 4 members to support this amendment because we have seen a number of times. How many times have we seen in the news after somebody loses their mind and chops somebody up or kills them? Oh, they were just the nicest person. So quiet. I can't imagine that this happened. This is crazy. We never thought that little Johnny would have done that. And that's an homage to one of our former members, little Johnny, Chair Marquardt. But this is the point that we tried to make benignly in committee, that if you're going to have these organizers, and you've got the votes to make that happen, you should say before they are allowed into the building that they should undergo a background check with the intent of weeding those people out that we sometimes hear about in the news being such a quiet kid and he's just apparently misunderstood and we're not sure how he snapped. So members, I would encourage a green vote on this. It's a very easy thing. Thank you, Madam Speaker.
To the member from Ramsey, Representative Perez Vega.
Thank you, Madam Speaker. Tenants' rights to organize, I'm very proud to carry this and happy to see this in this House omnibus bill. And thank you to my Chair Howard and Vice Chair Abaje, who has mentored me in my first session, especially as a renter and as an elected official and as a member of this body who all of us in these seats are up for re-election this year. And I think about the two of rights of when we talk about organizing, because I come from a background of community organizing, in particularly in communities that have disparities when it comes to language barriers or fear of what it may seem to just have a question about public safety. And I think about how well these alliances, the alliance of all these tenant unions that have came from these organizations that are not only in the metropolitan area, but in greater Minnesota and serve all of Minnesotans when it comes to organizing and talking about rights. In particularly the 20 organizations that I've been able to meet with personally and talk about why rights for tenants to organize is important. These 20 organizations, I mean, I can name them if you'd like, and I do feel the positive and amazing work from the members that are here in the gallery of the chambers that work dedicated day and night, that if a tenant has a question, they've actually felt safe enough to contact those organizations when it is beyond just landlord delinquencies, but also the need to feel safe in their home, like children and families who don't know what those social services are, because these organizations provide that. And they've even gone to the extreme where they didn't start like a housing organization such as the great work like Homeline, but they've organized to create tenant unions like Westside Community Organization. I think about the fact that they all hire tenant organized to conduct their own background check, but I think about us running our campaigns as well. I think about that we have to get permission from a tenant to go into an apartment building like myself as a renter, to get permission to knock door to door to give folks information. They have to ask permission. We have to ask permission. Now, when I go inside those buildings, that I ask permission and get the consent of the tenant who have spoken to their management and to their landlords, whether it's a fourplex or more, I, majority of the time, don't go by myself. I go with my team. So I look at the organizations that are doing the work to talk about renters' rights with their team. And I, as someone that's running a campaign, going with my manager, going with my team, just like everybody in this chamber, I don't believe that our campaign goes through a background check or every member goes through a background check when we're going into these buildings. So it's very difficult to understand why this would be any different. When we're talking about tenants who have maybe, and it's not maybe, we've seen this. We've heard testimony from folks that haven't had their electric, their utilities fixed, or there's rodents, or there's the unimaginable. Or maybe there's also good things like, hey, we want to organize to have a cleanup. We're talking about Earth Day coming up here. And folks may not know about that, but these organizations are the ones that are doing the work in community to make sure that we have a community that is functioning, that is speaking about public safety, that is encouraging public safety in our spaces, because tenants deserve safety, whether it's from their landlord to understand those capacities and the capability of what it means, or maybe somebody is just a college student that's living on their own from greater Minnesota coming to Minneapolis or St. Paul to live close to campus and saying, we've never lived by ourselves before. Heck, we don't even understand how maybe there's a faster way of transportation to get to our job in the snow. Or maybe there is a family who speaks a different language that may not understand that what they signed is something that they signed for and they need a little bit of additional help. These are the organizations that conduct their background checks. Not everybody has the game plan to start with everything right, but that's why we're lawmakers here. That's why we create policy to make things better. And in housing, we're here to make things better for all Minnesotans, whether you're accounted for or not. All Minnesotans who pay to live under their roof, who pay taxes, who make sure that they want to provide a safe space and environment for themselves or their families, have justice. Because I'll tell you, I've seen those injustices. And I will assure you that not just one, but 20 organizations as a part of this alliance have helped and served Minnesotans to have a better livelihood and a justice in housing. I urge members to vote no.
Further discussion on the amendment. Representative Nash.
Well, thank you, Madam Speaker. Well, Representative Paris-Vega makes my argument for me. She said just a moment ago that folks who live in an apartment should feel safe in their home. They should feel safe. Well, how is it then that having the expectation that somebody should undergo a background check so that they can feel safe when that organizer comes in, how is that outside the pale? It's not. You know, I have kids that rent apartments, and I asked them about this, and they said, yeah, I think that if someone's coming in to do this very thing, they're going to have access, because they will have access, almost unfettered access, to be able to go around, that they should undergo a background check, if for no other reason than to add greater validity to the fact that they're there with apparently a good idea from Representative Paris-Vega. So the argument was made by Representative Paris-Vega to do a background check because she says that people should feel safe in their own home. Members vote green.
There being no further discussion, the clerk will take the roll on the amendment. Members, please vote.
Hi, Paul.
Will the clerk call the names of the members voting remotely?
Carroll.
You're up, Ned.
Carroll, no.
Carroll votes no. Daniels.
Daniels votes yes.
Daniels votes aye.
The clerk will close the roll. There being 61 yeas and 69 nays, the motion does not prevail and the amendment is not adopted. There's an amendment at the desk. The clerk will report the amendment.
Myers moves to amend Senate File Number 3492, the third engrossment as amended. The amendment is coded A23.
To the author of the amendment, the member from Hennepin, Representative Myers.
Okay, yep, probably. Thank you, Madam Speaker. First, I would like to move to divide the A23 amendment between lines 2.8 and 2.9.
Representative Myers, could you say that again?
Yeah, we'd just like to divide this amendment up between 2.8 and 2.9. So the 1.1 through 2.8 discuss penalties, and then the 2.9 and beyond talks about the findings.
Representative Myers, it appears to be divisible, and so we are on the amendment starting lines 1.1 to 2.8.
Madam Speaker, would it be okay if we took up the second section first?
That should be fine, Representative. We'll go ahead and take on the division from 2.9 to 3.7.
Yes, Madam Speaker.
On to your amendment.
Thank you. So members, this amendment is making a finding that, we're trying to ensure that we find that balance in those regulations, those burdens that we put on housing providers so that we can promote that future investment, especially with some of the things that we've seen over the past couple years. We know effective regulations are going to both support tenants' rights, but we also want to make sure that we're providing those viable housing opportunities so that we have a healthy rental market and we're not taking away opportunities for private dollars to come in. And so I'm asking members to support this amendment.
The member from Hennepin, Representative Agbaje.
Thank you, Madam Speaker. I believe we're on the part of the division that's the bottom part. Okay.
That is correct, Representative Agbaje.
Thank you, Madam Speaker. While I do agree that there definitely is a housing crisis at all points across the housing spectrum, and that building more housing and the preservation of more housing is very important. Housing is more than just the structure. It really is about the people who live there, who are creating a home. And renters should be afforded to have similar rights to homeowners. And just because a family rents doesn't mean that a landlord should be able to disrupt their home life because they can't meet their obligations for a clean environment or addressing repairs in a timely fashion, or they're not investing in security measures. So I would just say that on this, while I understand the purpose behind the public policy and wanting to create like this fair environment where landlords and builders of housing are uplifted. I think we do that in plenty of ways in this legislative body. Our housing committee, especially last year, put forward a number of legislation to really ensure that we were investing in housing, investing in home ownership, investing in more building of housing. And so we will continue to do that. And I think, this bill in front of us, the underlying bill, is really about ensuring that those who do need to rent also have the same access and ability to build a home as someone who is a homeowner. So I would vote no on this amendment.
Further discussion. Representative Myers.
Thank you, Madam Speaker. Thank you, Representative Agbaje. The purpose of this was really to try to find that balance, both for renters, providers, homeowners, everything that we talk about in the housing committee. I think, there's a lot of things we can agree on in that community or in that committee. And one of those is, everybody wants a home, and a home is an apartment. It's a townhouse. It's a lot of different things. And that's what I was trying to accomplish here. And so I would ask members to support this, and I would request a roll call.
A roll call has been requested. Seeing 15 hands, there will be a roll call. Any further discussion to the amendment? There being no further discussion, the clerk will take the roll. On the second portion of the A23 Myers Amendment, starting lines 2.9 to 3.7. Members, please vote. Will the chief clerk please call the names of the members voting remotely?
Carol.
There you go.
Carol votes no.
Carol votes no. Daniels.
Daniels votes yes.
Daniels votes aye.
The clerk will close the roll. There being 61 yeas and 69 nays, the motion does not prevail and the amendment is not adopted. Representative Myers to the second part of the divided amendment, starting fourth portion from lines 1.1 to 2.8.
And thank you, Madam Speaker. So, this part of the amendment, talks about penalties. And again, for me, I'm always trying to find that balance, and that balance is, again, the rights and protections of tenants by also making sure that we don't increase the cost so much that, it makes housing even less affordable for people. I think the provisions in the bill as they stand, if passed, can have significant impact, on housing providers, managing those, increased fees, increased risks. What I do want to say is I really appreciate Representative Abaje talking with me about this. We're really trying to look for that balance, and I hope that we can continue to have that conversation on what some of these penalties look like, where some of these penalties came from, and I'm hoping that future conversations later, conference committee can be had so we can really strike that balance. And Madam Speaker, I would withdraw this amendment.
Representative Myers withdraws the amendment. There's an amendment at the desk. The clerk will report the amendment.
Johnson moves to amend Senate File Number 3492, the third engrossment as amended. The amendment is coded A18.
To the author of the amendment, the member from Isanti, Representative Johnson.
Madam Speaker, members, this amendment removes Article 6 on page 35 of this bill. What it does is remove the discrimination in housing assistance. But what it removes is this section is falsely named. It removes the requirement that any property owner or housing provider, whether you rent out a bedroom or a huge nonprofit with 300 units, it requires you to take Section 8 housing. In Section 8 housing, to qualify for that, you also have to sign a contract with the federal government. So we're forcing people to sign a contract with the federal government. And to get that contract, you also have to do have your if it's a bedroom in your home, have your home inspected every year. A 19-page inspection report has to be filled out yearly. And if you live in the city of Minneapolis, you have to biannually inspections as well. Oh, but then you have to have your license that for renting that in Minneapolis, it's once every 7 years generally, occasionally 5 years, and once in a while every year, depending if there's problems. Why anybody wants to rent anymore, I don't know, but this is just going to make it worse. So what this bill does is removes that requirement, lets people decide whether they want to use that program or not. Let them make the choice. In fact, the program is called Housing Voucher Choice. The choice of the housing provider to be in the program or not. Not a mandate, a choice. They should have that choice. Members, please support the amendment.
The member from Hennepin, Representative Agbaje.
Thank you, Madam Speaker. I will suggest that members vote no on this amendment. No one should be allowed to discriminate, especially in the area of housing. Discriminating against a potential renter because of the source that they use to pay their rent is often a proxy for discrimination for other protected classes. Landlords, they have to register for licenses, they buy insurance, they complete all types of other regulations in order to offer housing in this market. This should be no different. If you're offering goods in the marketplace, you should not be allowed to discriminate. Prohibition of the source of income discrimination already exists in 20 states across the country, and those protections have not interfered with the business of those states, and they have already adopted provisions to protect voucher holders and other people who rely on public assistance for their rent. Minnesota, unfortunately, has some of the worst housing disparities also in the country, and we don't want to open the door to creating more of those disparities by saying that you can just turn away someone's rental application because you notice that they would be paying the majority of their rent through government help. What we want to do with prohibiting source of income discrimination is ensuring that Minnesotans are empowered to have a meaningful place to live, and that the state is also meeting its duties when it comes to federal fair housing. So this is something that we strongly really want to ensure that everyone in our rental community, no matter if their income comes from a high-paying job or their income comes from the federal government or from the state of Minnesota through our new housing voucher program or from local ordinances, we want everyone to be able to have that fair opportunity to find a place to live. So I would encourage members to vote no on this amendment.
Further discussion on the amendment. Representative Johnson.
Madam Speaker, members, Representative Agbaje, I understand what you're trying to do. But forcing people to sign a contract with the federal government is not the way to do it. We're in a free country, a country that you can choose what you would like to do. Do we have some rules and regulations and laws you have to follow? Absolutely. Is discrimination bad? Absolutely. But we also have to, a person also needs to live within their means. Just because I want to live in a $5 million mansion doesn't mean the government should pay for it. I have to find housing what I can afford. Is there programs out there to help? Absolutely. But it should be the choice of the property owner and the housing provider if they want to participate in those. That's why the program is called choice. It's the choice, not only of the person that wants to use the program, but also the person that wants to receive it. We have a lot of housing issues, housing shortages. With this on there, I think it's going to create a bigger problem. Because I've talked to housing providers, and I know what they're going to do. They've told me what they're going to do. It's going to actually hurt the market. It's going to make those in the middle class that don't qualify for the program, it's going to make it harder for them, which is not what we want to do. Members, please vote for this amendment.
There being no further discussion, all those in favor of the amendment say aye. Those opposed say nay. The motion does not prevail and the amendment is not adopted. There's an amendment at the desk. The clerk will report the amendment.
Johnson moves to amend Senate File number 3492, the second engrossment as amended. The amendment is coded A19.
To the author of the amendment, the member from Isanti, Representative Johnson.
Well, we'll try this one more time, Madam Speaker, members. What this amendment does, it bypasses so single-family homes are not in the program. But if you have a duplex or bigger, guess what? You have to participate. What it says is when a landlord accepts federal, state, or local government rental assistance from a unit in a residential building, then they have to accept them whenever one comes along. That's important. If they're going to do it for one in their building, they should be able to do it for all of them. And that's what this amendment does. Please support the amendment.
The member from Hennepin, Representative Agbaje.
Thank you, Madam Speaker. Again, I'm going to ask the body to vote no on this. The proposal in this amendment, I guess, would only apply to landlords that are currently accepting or currently have public assistance. I think that this could lead to a concentration of communities creating these neighborhoods that the only people who live there are the people who are on public assistance in some shape or fashion. I think that that would actually lead to further discrimination and segregation in our society through housing, which we all know what the history of redlining has done to our communities, which many of us are still reeling from today. So we should not allow that to happen, which I think is what would happen through an amendment like this. Again, landlords are in the marketplace. They've got to offer goods and services to everybody. We cannot allow this loophole to allow them to discriminate against folks just because they would have their income coming from the government. And in fact, actually, many landlords like having Section 8 or public housing assistance because it's actually guaranteed income from the government about that portion of the rent. So I would encourage the body to vote no on this amendment. We don't want to inadvertently create more segregation and discrimination in our society through housing. Thank you.
Further discussion. Representative Johnson.
Madam Speaker, members, Representative Adjei, I'm sorry to hear this. Give a little more information on housing choice or housing voucher choice. The federal government gives the state of Minnesota X number of dollars. And the state doles it out to different organizations, different groups, most usually nonprofits, or like in the Minneapolis Public Housing Authority. But guess what happens if the money starts running out? What happens is the payment by the federal government, or which the state takes care of it, is reduced. And guess what? The housing provider can't make the tenant make up the difference.
As we push more and more people onto the program, there's less and less money to go around. What happens when the property owner or the housing provider is cut in their payment from HUD, and now he can't make his mortgage payment on the property? Goes into foreclosure. Can't do the maintenance that needs to be done. Now he got violations. And he gets fined more. And we'll talk about fines later. Give the housing providers a little bit of leeway while we still have some. That's all I'm asking. Please support the amendment.
There being no further discussion, all those in favor of the amendment say aye. Those opposed say nay. The motion does not prevail and the amendment is not adopted. There's an amendment at the desk. The clerk will report the amendment.
Petersburg moves to amend Senate File Number 3492, the third engrossment as amended. The amendment is coded A20.
To the member from Waseca, Representative Petersburg.
Thank you, Madam Speaker, and let's try this one because I think this one's common sense. It actually has some basis in federal regulations as well, and I think something that everybody can support. Got to remember that a lot of the regulations and rules that we're putting into this bill here have some basis, if not direct subsidy from federal programs. And even the federal programs know that there are some limitations to what you can expect of housing providers and those that are providing low-income housing, et cetera. And one of the terms that they use is undue financial and administrative burdens. And what this amendment does is it says that if some of these rules and regulations would create such a problem that there would be undue financial and administrative burdens, that it would not be required and it would not create a violation of this bill and of the discrimination piece. Now, why is that important? Well, the federal government understands that if you put too much onerous onto owners of properties and it becomes to the point where they can't stay in business or they are finally losing money, they have a few choices. One of them is to sell the property or to go bankrupt, let somebody else redevelop it. And the federal government understands then people lose those facilities and those homes altogether. So they understand there has to be some juggling act. And I understand that we're kind of juggling here between the needs and desires of the tenants, but we also have to deal with some of the realities of those that are providing the housing. And so I'm trying to help here so that we don't get in sideways with some of the rules and regulations of some of the federal programs and actually put higher restrictions on us. Because after all, what we're here for is to try to provide an even balance. So I understand that, and I hope that this finds support in the chamber here, and I would certainly ask for a yes vote.
To the member from Hennepin, Representative Egbaje.
Thank you, Madam Speaker. Thank you, Representative Petersburg, for offering the amendment. Unfortunately, again, I'm going to have to ask the body to vote no on this amendment. The purpose of this provision is to prevent discrimination on those who use public assistance as their source of income to pay their rent. As I noted before, many landlords who are in this system see that their rent comes in on time and paid by the portion that is covered by the government assistance. And for those who can't even pay that small portion of rent that they would owe, there are still processes in either which to obtain that rent or evict them if needed. We haven't eliminated eviction. And so I would just say that I don't think it makes sense for us as a body to create these loopholes where someone can say, trying to make sure that I am a participant in society that is not going to discriminate against people, that we give them a loophole because of an undue financial or administrative hardship. Who decides what is an undue hardship? I would just urge the body to vote no, and we should not be allowing discrimination. We should be closing those loopholes when we see them.
Further discussion. Representative Petersburg.
Thank you, Madam Speaker, and I'm going to clarify something here. But first, before I do, I would request a roll call. I think this is important for us to deal with. And
Instead, there being 15 hands, there will be a roll call.
Thank you, Madam Speaker. What I want to clarify is that I know that this section that is being attached to deals with financial costs and others, but if you read my amendment very closely, it says when the cost of meeting the terms and conditions in the public assistance, rental subsidy, or housing voucher programs would create this undue financial burden. It's not talking about discriminating against somebody from paying it. This is just saying when we have an issue in regards to the terms and conditions of trying to meet these programs, that it would not be under violation. And so that's clearly, I think, something different. And so I'm hoping that you might, Representative Agbadje, might reconsider that, and you certainly can nod to the Speaker if you do. But I would absolutely encourage a yes vote, because this is one of the protections in order to make sure that we keep reasonable cost housing available for the people who we're trying to help. Thank you, Madam Speaker.
The member from Isanti, Representative Johnson.
Madam Speaker, members, Representative Petersburg, thank you for this amendment. We need something like this because I don't know if you've read, but there's a 19-page inspection that has to be done with many things that may have to be fixed. It may be unaffordable for the property for the housing provider to fix everything in order to qualify for the choice program, housing voucher choice program. But it's not just the HUD inspection. If you're in Minneapolis, you also have the Minneapolis Public Housing Authority doing their inspection. Or you also have the city doing their inspection for your renter's license. And if any of them come up where something comes up, it could stop them from being able to rent to that person. So, and then it could end up going to the Human Rights Department for a civil rights violation, by the way this is written, which isn't good. Had good intentions, but he ended up with a civil rights violation. Representative Badgie, I don't believe that you want that to happen. So members, please take the Petersburg Amendment.
Any further discussion on the A20 amendment? Seeing none, the clerk will take the roll on the amendment. Will the chief clerk please call the names of the members who are the members voting remotely?
Carroll.
Here you go.
Carroll, no.
Carroll votes no. Daniels.
Daniels votes yes.
Daniels votes aye.
The clerk will close the roll. There being 61 ayes and 68 nays, the motion does not prevail. The amendment is not adopted. There is an amendment at the desk. The clerk will report the amendment.
Kosnick moves to amend Senate File Number 3492, the third engrossment as amended. The amendment is coded A22.
The member from Dakota, Representative Kosnick.
Thank you, Madam Speaker and members. I offer the A22 amendment for an important purpose for your constituents, and it's to protect private property rights. What the amendment does is permits that an individual may be removed for trespassing or arrested for trespassing if they're occupying a property that they do not have a lease or sublease rights to. We've seen more instances of this, and there was a story of a gal, her mom died, and her name was Nina. And so when her mom died, her mom's apartment was empty, and she was in the process of cleaning it out, that maybe some of you have experienced when your parents have passed. And the property sits vacant for a little bit. And she went to go clean the apartment up, and there was some people occupying her mom's apartment, and they killed her and stuck her in a duffel bag and put her in the closet. And Nina's son was a little concerned because he hadn't heard from where his mom had been for a couple days. And so they kind of tracked down what the steps were, and they went to the grandma's apartment. The caretaker let them in to the apartment. They looked around, got by the closet, and they saw the leg sticking out of the duffel bag. And in that duffel bag was the mom. We need to protect private property rights, and the people that were in that apartment weren't on a lease. I'm not sure why they were in the building, but they basically took over the apartment, and it could be a house, it could be a cabin that you have up north, it could be a second home that's a little bit more remote out in some farmland. It could be a condo that you have in downtown Minneapolis that you use for business, or a lot of second homes. And so we need to protect private property rights. I had another story of just this week. I met with the Mobile Home Association people, manufactured home. This gentleman, there was a community, a mobile home community in Staples, and he bought it. There was about 19 units there that had been neglected, and so he bought the community from the previous owner. Most of the people had moved on to wherever they were moving on to, and he was taking all 19 of these dilapidated homes, taking them out and replacing them with brand new double-wide mobile homes and providing some very good affordable housing. But there was one person that broke in the door and started living in one of the old mobile homes. There was no electricity hooked up, but this family that was trying to create better affordable housing had to pay $3,000 to have an attorney to serve this person and to get them kicked out and evicted. But he had no lease rights. He was not a sublease. He just moved in because the property was vacant, and he took advantage of that, and we're seeing more and more of this. And so this person had to go through the whole eviction process. What this amendment does is it permits him to, or anybody else, if somebody is occupying a property, to just have them under the trespassing laws and have them removed on the property. And the story of Nina and her grandma and her son finding them, that was in New York, in Manhattan. But more recently, you can look it up on April 6, 2023, Fox 9 did a story about squatters infiltrate a Minneapolis apartment building. So this is right here in Minnesota. And the residents of the apartment building were fed up with squatters, and in this case also unresponsive management. One of the other tenants in the building said, "I feel abandoned and I feel like I'm living in a garbage dump." She didn't want to give her name because she feared retribution. People had broken into this apartment building and occupied unoccupied or unrented apartment buildings, and they were living there, and they were being violent and really interfering with the quality of life of these Minneapolis residents. She said, "I was afraid to leave my room without pepper spray. I'm afraid that if I leave my room, it will get broken into, and my life has been negatively impacted for quite a while." And so we need this amendment. This is not a dispute between somebody not paying the rent, somebody being 3 days late on the rent, somebody having a lease interest and subleasing it to somebody else. This is for when somebody just takes over personal, private property. And property owners, whether it's a big apartment building like this incident in Minneapolis, or it could be a private condo that you have, maybe you went on vacation over spring break and somebody came back to your apartment or your house, let themselves in, and you have to get them out after a certain time. You don't need to, we shouldn't have to pay $3,000 to hire an attorney and serve these people and have them evicted. We need to clarify and strengthen the trespassing laws. And so just real simple bill, or simple language in the bill, an individual may be removed for trespass or arrested for trespass consistent with other statutes in the bill. So, Madam Speaker, colleagues, I ask for your support to protect personal private property rights.
The member from Hennepin, Representative Agbaje.
Thank you, Madam Speaker. Thank you, Representative Koznick. A lot of those stories sound really tragic and very unfortunate. Unfortunately, I'm not entirely sure that this language actually gets at the situation you're trying to get at. So for that reason, I would encourage the body to vote no. In the situations, in Minnesota, I think people get confused about what the term squatters' rights actually means. In Minnesota, it's actually, what it means is actually a process called adverse possession. And in Minnesota, in order to be able to overtake someone's property to try to claim and actually have a real claim that you live there, you need to have been actively living there for 15 years, and in some time during that 15-year process, pay property taxes for 5 consecutive years. So if someone has not yet done that, you then actually have the ability to push them out either with local law enforcement or just kicking them out of your home because they are, in fact, a criminal trespasser. So I would say that that's actually the situation that is right now in Minnesota. We don't really have similar squatters' rights, for lack of a better term, that other states do that make it easier for someone to try to overtake a property. I think you're also not talking about holdover tenants, but similarly, those also have a different process for removal as well. So I would just say that I think a topic like this probably needs a little bit more work. As we discussed, there are a couple of different groups that might be interested in this, so it'd be interesting to talk more with them and figure out what language would actually look like to figure out these types of situations when someone is there and maybe they've only been there for like a week or something. But I think mostly in those types of cases, what people are doing are using the criminal trespass procedure through law enforcement. So I would encourage a no vote on this amendment.
Discussion to the amendment. The member from Isanti, Representative Johnson.
Madam Speaker, members, Representative Koznick, thank you for this amendment. I've actually had to deal with this as a road deputy. It took about 3 months to get the squatters out because we had to use the eviction process. The owners came home from being snowbirds. And thankfully, they had an RV. They had to live in their RV for 3 months before they get back in their home. So what happens? It's ugly. But the eviction process for this doesn't work. Those people that are doing the squatting, they're actually doing a burglary, breaking into your home, taking possession of your home, and not giving it back. All they have to do is get a piece of mail delivered to that address in their name, and they have tenant rights. It's unfortunate because this is an issue that's going to get worse. It's going to keep getting worse. We had a fentanyl problem. We have a huge fentanyl problem. I've been dealing with that, trying to get stuff done. We finally got it done last year, but I was working on it for 10 years. How many people died because we didn't get it done right away? Let's get on top of this before it's a huge problem. We have an opportunity right now. If you don't do this now, we have a possibility of somebody getting injured or killed. When they come home from being a snowbird or from vacation or the hospital, where you end up in the nursing home for rehab, and find somebody in your home that took possession of it. We have an opportunity right now to give law enforcement the tools they need to deal with the situation and get the property back into the rightful owners. It's your choice whether you want to make sure that the property owner is able to keep their property and be able to sleep in their own bed, or give it to somebody else that has no rights to it. Please vote in support of the amendment.
Further discussion to the amendment. The member from Dakota, Representative Koznick.
Thank you again, Madam Speaker, and Representative Abaje. You know, that Minneapolis apartment building has basically been taken over by people that don't have a right to be there. And it's not some wealthy guy out in the suburbs or something, or some other family. That building is owned by a nonprofit, and I don't want to embarrass them by saying it on here. But basically, because it's been difficult to go through the eviction process, and they have no lease rights with these people. They kind of broke into the building, and they're even sleeping in the hallways when the news crews were there. They said that it's been an unfortunate delay in completing some of the repairs due to the presence of threatening behavior by unauthorized people in the property when they come to give maintenance to it. So they've had to work with the police and to try to clean up the property. So basically, this investment of a large probably used to be affordable housing, probably is very affordable now if you're there for free, just walk in. We need to have and protect these private property rights. Whether it's this nonprofit or some other investor or some small investor that wants to do the rental properties on the side, or even just your own home. We need to protect property rights. I hope you'll reconsider and take this amendment. Madam Speaker, I would request a roll call. And members.
Representative Koznick requests a roll call. Seeing 15 hands, there will be a roll call. Representative Koznick.
Members, you can feel proud of voting for your constituents and their personal property rights that are very important to everybody. So I appreciate a green vote.
Any further discussion on the A22 amendment? Seeing none, the clerk will take the roll on the amendment. Will the clerk please call the names of the members who are voting remotely?
Carroll.
There you go.
The clerk will take the roll on the amendment. Carroll, no.
Carroll votes no. Daniels.
Daniels votes yes.
Daniels votes aye.
The clerk will close the roll. There being 61 ayes and 68 nays, the motion does not prevail. The amendment is not adopted. There is an amendment at the desk. The clerk will report the amendment.
Franzen moves to amend Senate File number 3492, the third engrossment as amended. The amendment is coded A24.
The member from Douglas, Representative Franzen.
Thank you, members. Thank you, Madam Speaker. The Star Tribune, January 12, 2024, reports that Minnesota is a top destination for migrants accepting free tickets to leave New York. The CBS News, this was recent, January 19, 2024, Minnesota organizations look to find housing as number of asylum-seeking families reaches all-time high. We have an article from the Newsweek in January 10th, migrants get up to 2 years free rent for new apartments. Members, we have a housing crisis on our hands here in Minnesota, across the nation as well. A real housing crisis where families are unable to find rentals. That's why we're putting so much money into affordable housing, so we can build up more housing and apartments and homes for individuals. And I do not think that we should be renting to those who are here illegally. So this amendment addresses that. Just basically says that a landlord, can deny a person that is here illegally. We should be prioritizing our own citizens. I'm not sure if you've looked outside lately, but homelessness issues are out of control as well. We can't even take care of our own citizens. I don't believe that we should be giving housing to those who are here illegally either. So members, I would request a yes vote on this very solid amendment. Let's put Minnesotans and legal citizens first. Thank you.
There's an amendment to the amendment. The clerk will report the amendment.
Egbadje moves to amend the Franzen amendment to Senate File number 3492, the third engrossment as amended. The amendment to the amendment is coded A26.
The member from Hennepin, Representative Egbadje.
Thank you, Madam Speaker. I would encourage the body to vote yes on this amendment to the amendment. What the underlying amendment is doing is essentially taking the I-10 provision that we have where landlords can both accept Social Security numbers and I-10 numbers and trying to say that those who do not have, legal immigration status or some type of citizenship should not be able to be rented to. I think that would be dangerous territory for us to go on. So what the amendment does is just says that all legally required information to help the landlord use that I-10 number to be able to get a fuller credit report is what the amendment would do. I'm really encouraging members to vote yes on this amendment to the amendment. Otherwise, what the underlying amendment as it currently is would not probably, but most likely put us in violation of fair housing laws of the United States and of the state of Minnesota.
Discussion on the Egbadje amendment to the amendment. The member from Isanti, Representative Johnson.
Madam Speaker, members, I request that you vote against this amendment. The underlying amendment takes care of a problem, actually puts us in line with the federal guidelines of HUD. Because in order to use federal money, you either have to be a citizen or have legal status in this country. Unfortunately, with the state dollars, they don't have to. And this would require the state dollars to also have the same requirements as the federal, which is important. So members, please vote against this amendment. And Madam Speaker, I request a roll call.
Representative Johnson requests a roll call. Seeing 15 hands, there will be a roll call. Further discussion on the A26 amendment. Seeing none, the clerk will take the roll on the amendment to the amendment. Will the clerk please? Would the clerk please call the names of the members voting remotely in reverse alphabetical order?
Daniels.
Daniels votes no.
Daniels votes no. Carol.
There you go.
Carol, yes.
Carol votes aye.
The clerk will close the roll. There being 68 ayes and 61 nays, the motion prevails. The amendment to the amendment is adopted. On the underlying amendment as amended, discussion. Seeing no discussion, all those in favor, please say aye. Those opposed, please say no. The ayes appear to have it. The motion prevails. The amendment is adopted. There are no further amendments at the desk. The clerk will give the bill its third reading.
Third reading, Senate File Number 3492, as amended.
Third reading as amended. Discussion to the bill. The member from Isanti, Representative Johnson.
Madam Speaker, members, when we do the housing bill and the housing, especially policy, we have to make sure that we have a balanced approach to the tenant and housing provider laws. That means working together with both of them to do that. While the other body's bill worked and agreed upon with all parties, this bill did not. It added 19 pages to the bill compared to the 16 pages that were agreed upon by the parties. Does that make it balanced? No. In those 19 pages that were added, housing providers are not able to manage their property the way they see fit due to the provisions such as the prohibition of denying an applicant based on pending evictions. What if the pending eviction was a safety concern for other tenants where the eviction was occurring? Eviction due to damage to property. There are several eviction reasons beyond non-payment. It requires providers to accept government assistance programs, either federal or state programs, which requires a housing provider to sign a contract with the federal government to participate in Housing Choice Voucher Program, requires yearly inspection with a 19-page inspection report. And what I found was interesting for Minneapolis, they are required to do the inspections yearly by HUD. And it seems interesting. I was able to find out this information on the Minneapolis's website. Minneapolis Minneapolis Public Housing Authority inspects units before a tenant moves in, and at least biannually, which means once every 2 years, even though it's required every year. The city conducts their licensing inspections on a 5 or 8 year cycle. Only a small percentage of rentals are inspected annually. Oh, but they're required if they use housing choice vouchers to do it annually, but they don't. MPH inspections are conducted contractually required to do the inspections to receive the voucher programs, but they don't do the inspections annually that they are required to by law, by federal law. Representative Badger, maybe if Minneapolis followed HUD's laws and requirements and rules, maybe the issues you're having in Minneapolis would not be happening. Because in my community, they're not. And I've talked to many members from greater Minnesota. We don't have these issues. You can shake your head, but that's the truth. Then we have the tenant right to repair. Permits the tenant to fund their own repairs without approval of the housing provider, leaving more questions than answers. Liens, warranty of work, liability issues if something should go wrong. Makes me concerned. Then over-penalizing housing providers. New mandatory minimum penalties. 21 of them, in fact. Now, I think it's much better for the courts to have some discretion to decide the fine, if there should be one, for what is best depending upon the totality of the circumstances on the violation. The violation might not have been the housing provider's fault, but he gets the fine. It might be the tenant's, something that the tenant did, but the housing provider gets the fine. Members, this bill is another attempt to fix an issue that's happening in the city of Minneapolis, in the Minneapolis area, and not in the greatest part of the state, greater Minnesota. This bill it affects the entire state, putting affordable housing at risk in an area that is desperately needed, and that is in greater Minnesota. I had mentioned earlier that I'm going to explain what some of the housing providers said that they might do should this go into law. And that's the first opportunity they're going to jack their rates up. Because at a certain point, they will not qualify for the housing choice vouchers because of the rent rate. Because it's limited how much HUD spends. So that's going to hurt the middle class that's renting. Unfortunately, over the past few years with Biden inflation, it's caused a lot of things to go up. And it was interesting, I was reading, the average home maintenance cost has gone up 20% every year for the past couple of years. You wonder why rent is going up? Why rent for our seniors is going up? It's because of the policies that are putting in place. It's because of inflation. So members, please vote against this. We have a bill that had bipartisan support that came out of the other body. It was worked on by all parties. All parties agreed to it. Yet instead, we added 19 pages onto a 16-page bill, and it's no longer a bipartisan bill. It's a bill that's going to hurt our housing industry, housing provider industry. It's going to have the opposite effect of what you want to happen. It's going to cause rents to go up, or people just quit renting. Housing providers do a great service. The vast majority of them are good. Do we have some problem ones? Just like anything else, there's problem ones. But this hammer that's being used when You could use a scalpel, and maybe if the city of Minneapolis did what they were supposed to do, we wouldn't have this issue. But this is the wrong approach. We had a nice, clean bill that had bipartisan support that came out of the other body. Let's reject this one and send it, and then take up the original bill that we were supposed to do today and pass that on very quickly.
The member from Hennepin, Representative Agbaje.
Thank you, Madam Speaker. And thank you, members, for the robust debate tonight. I actually feel honored because the last time we had a tenants' rights bill up, we didn't have any debate. So this bill does a lot to kind of further ensure that tenants' rights across the state are upheld and ensuring that we're making sure that tenants and landlords have a more equal playing field should they find themselves in court. Again, all of these bills and provisions that we're putting in are in the interest. If you find yourself in court, here are the rules. The judges know what the rules are. There's guideposts for the judges to be able to figure out how to rule on these cases. I think it's really important that we, uplift the various pieces of this bill that will continue to support tenants in their efforts to create homes for themselves and their families, with the tenant right to organize, ensuring that survivors of domestic violence can get out of their leases should they need to, that tenants who need to call for emergency services, including mental health, can do so, that we have a more streamlined process for the eviction process, and that we also are allowing landlords to use ITIN numbers in addition to Social Security numbers so more people can have access to applying for a place to live. These and many more provisions in the bill really just ensure that tenants have a more equal footing with landlords, that they feel confident in the courtroom should they find themselves there, and that they have a better understanding of what the rules and regulations are, both on the tenant side and on the landlord side. This is really simply for clarity. On the pieces about the remedies, it is really just signaling to the courts, here's a starting point for you. But they still have full discretion in deciding what those damages, if any, should actually be. And so I would just like to close again with thanking everyone for their time today, thanking everyone for their comments, thanking staff who helped with putting this all together, thanking all the advocates who gave their input. And as this bill continues on, because we do have different provisions than the Senate, and the Senate has different provisions than us, look forward to bringing it back once we have ironed out all of those things. So I urge a green vote on this bill. Thank you.
The clerk will take the roll on the bill. Will the clerk please call the names of the members who are voting remotely? Members, we're not done yet.
Carroll.
Carroll, aye.
Carroll votes aye. Daniels.
Daniels votes no.
Daniels votes no.
The clerk will close the roll. There being 68 ayes and 61 nays, the bill is passed as amended and its title agreed to.